My name is Jim Hagman. I get the honor and the blessing to be the mayor of this great city. And I absolutely love to do what I do, but before we go on and talk to our esteemed guests, I want to a couple of thank yous. First of all, any event that happens, a lot of work goes on behind the scenes. So in this particular event, some particular city staff, I want to thank Robert Brewer back there and his team for getting all of this together. I also want to thank, he's not in the room, but Mr. Kelly Frey, who is the owner of this amazing facility, who provided this for the city of Spring Hill. Mr. Kelly Frey. And then I would like to recognize some other elected officials that are in the room. There are three that I see. Mr. John Canapari, if you'll stand, sir. Mr. Trent Linville, who is one of our aldermen. And Mr. Matt Fiddler, who is our alderman. Matt, are you here? I saw you. I guess he's powdering his nose. And Miss Alderman Nieves, Miss Hazel. I didn't see you, Hazel. You're right there. Thank you. And then additionally, there are several people in the audience that serve on our citizens commissions or committees. And I see Rob is on our Board of Zoning Appeals. This is Rob. Rob, thank you for being here. But this event also takes into account for behind the scenes people, that the people that really got this together is our city administrator Pam Caskey and our city attorney Mr. Patrick Carter. Gentlemen, the city of Spring Hill is absolutely honored that you are gracing us with your presence. I mean that from my heart, and I'd like Dr. Carter to introduce you. Mr. Carter.
Hey everybody, I'm so glad that you're here today. It's wonderful to work for a city and a city administrator that allows us to do innovative things like this symposium. 9 years ago when I became city attorney, I didn't know we'd be having symposiums 9 years later, but I'm excited. Vested rights is such an interesting topic, and excited to see the crowd here. Let me introduce Tom White and Sam Edwards. Tom is both these guys are the preeminent practitioners in the field of land use and vested rights in particular. They are both lawyers. They both practiced in land use planning. In 2014, when the vested property rights became law, these were the two guys that were the titans in working on behalf of their clients. Sam more on the city side and Tom on the developer side, and we ended up with this statute that we have that we're charged with interpreting as planning commissioners, enforcing as land development lawyers, as planners trying to figure out what it means. And so I'm excited to have them here today to enlighten us with their wisdom. Before we begin, we're going to have a slideshow, but there is planner CE credit, and there's going to be attorney CE credit. If you need anything from the city to get that, please feel free to follow up with the email, and we can get you a letter of your attendance. My understanding is staff is still working on the details of that, but our intention is that there'll be CE credit for today's program. So without further ado, Sam and Tom, and we can start the slideshow, and we will go from there.
Okay, Pam, thank you. If you'll be running this through. This is about 15 minutes of a slideshow. It was actually put together by my law partner, George Dean, who is basically, in my opinion, the best institutional lawyer with knowledge about land use cases, and I'm sure if you guys have attended many seminars, you've heard George. But basically, we're dealing with three cases today. I'm going to deal with the first two. Sam's going to deal with the third one. But basically, we're talking about two cases initially. One is the Howe case, and as George comments appropriately, Howe case is a case from 1940 in Nashville. The later case, which is really the Hoover Quarry, is many years later. One was a decisive loss for the property owner, one was a decisive win. And I'll comment at the front end, the term vested rights gets thrown around all the time, sometimes knowledgeably, oftentimes not knowledgeably. People would just think I've owned a piece of property for a long time, I've got certain rights. Probably incorrect. But at the end of the day, vested rights is a term that's been used around the country for a long time. the premier states that really came with the initial decisions are really the states of New Jersey and California. But if we can go to the next slide here. Okay. The Howe case, 1940, a Nashville case. There's some people here in the room that know this background of this case extremely well. But Shell Oil had an option on a piece of property. If you use the node Nashville, it's directly across from Vanderbilt. It's where the Lowe's Vanderbilt Hotel is right now. Shell had an option on that property. They were going to put in a gas station. The property was zoned commercial. So Shell did all the right things. They went down to the city of Nashville. All the cards were on the table, had good engineers, and basically they made a building permit. They got the building permit issued to build a Shell oil station on that corner there at 21st. There was some concern by the city council. All of you are aware, this is pre-Metro government. Metro government came in 1963 when they merged. And we now have 40 council members, 35 districts, 5 at large. This was a time where it was city-county, and basically Shell Oil went down to get the permit. It was issued. The district council persons of the area didn't want a gas station in that location. So there's something in this terminology I think is a dying art also, a gentleman's agreement. There was a time when you shook hands with people in government and other places and counted on them doing that. Sometimes that's the case. It certainly is in Spring Hill. It's not so much in other places. So I'll mention to you that what took place was everybody agreed they would stand back and see what the political ramifications would be. The council person of the area took the commercial zoning and took it down to residential. And that was it. They went to the court. The court determined that there had been not enough substantial reliance on the building permit. Now, basically, before the Vested Rights Act of 2014, what the law required was a building permit and significant investment. Now, that second issue was a critical one. The building permit is pretty simple. You can go down to the city and see if somebody pulled a building permit. But the issue of significant development reliance was a very subjective matter. And I tried a number of these cases under the old law. And you were subject to generally Chancery Court cases. You were subject to the Chancellor's decision about whether or not substantial development had taken place. And I've had cases where the developer, my client, had spent a couple $100,000. The Chancellor thought it wasn't significant. Had other cases where clients spent $15,000 or $20,000. The Chancellor thought it was significant. So it was just it was a roll of the dice every time. But that issue continued to permeate, and people that dealt in land use areas like me and Sam, my law partner George Dean, would always tell clients the same thing. It's a risk. Get the building permit, hope we draw a chancellor that will basically say there's substantial development. Sometimes you did, sometimes you didn't. If we can go to the next one. Basically, the court decided in the Howe case, again, it's 1940, that Shell really hadn't spent any significant money. One of the very frustrating things is that the courts would historically say soft costs didn't count. And so you could spend all kinds of money with engineers and architects, and almost across the board, they would say soft costs don't count. That's generally where a client spends most of the money up front with those crafts. Sometimes it's legal, but oftentimes architects and engineers. Again, with soft costs not counting in a lot of courts, you could spend a great deal of time and money and draw a blank. That's what happened in the Howe case. You all realize Shell Oil is not a small company. They had the money, they had the wherewithal, the handwriting was on the wall. Court of Appeals made the decision, that was the end of it. Vanderbilt Lowe's is on that site today. Let's go to our next one, Pam. There we go. This is the second case. This is what I always call the Hoover case, but neighbors of Old Hirky versus Metro Nashville. And I was the plaintiff's attorney who was Hoover in this case, and there's an individual in this room by the name of Bill Herbert, who was involved as zoning administrative member, the head of the codes department for 6 years in Metro government, knows these facts as well as I do. But this was an interesting case. The property was zoned industrial. This is out by the old DuPont plant. And so our client Hoover came and said, we'd like to think about a quarry on that piece of property. Well, it's a very interesting thing because basically this is after the Vested Rights Act of 2014. Now, all of you in the room know the Vested Rights Act is 2014. It became effective January 1 of 15. This client, Hoover, was smart enough to be watching that. our law firm was very much involved in the legislature and the enactment. Sam was involved, my law partner John Williams, George Dean, were all involved in the legislature, and you can never quite tell what's going to come out of the legislature. I mean, you think you got a pretty lucid proposal. By the time it came out, I think we understood what we had. But at the end of the day, it was a very positive thing because for the first time it said, you can have a building permit and you can do other things that will lock you in. It doesn't have to be a building permit with substantial reliance on development. It can be a building permit, it can be a site development plan, it can be different cities call them different things, but a far lower bar than just getting a building permit and substantial reliance. So for once you could lock in what government was going to do, and that's what happened in this case. My client and I, our engineers, spent a great deal of time in Bill Herbert's offices and other places trying to get locked in because guess what? Here's a very interesting thing. You don't have a building permit for a quarry. So think about this. You know, the old classic rule, get a building permit, it's like, whoops, there's no building permit for a quarry. So what do? Well, we got creative. We got a site development plan down there that we got vetted thoroughly with Metro. And that site development plan basically showed the quarry specificity. Exactly. It showed all the accessory uses, you know, the asphalt, all the other items. That was the development plan. And what happened as soon as we became public with it, what always happens, the district council person downzoned the property. He was going to downzone it by things like you can't have a quarry within 1,250 feet of a residence. Guess what? We were within 1,250 feet of a residence. That's what always happens. So either we were going to win on the vested rights or basically we were going to have it undone. And so in this case, we tried the case. Judge Davies tried the case as a special judge, went to the Court of Appeals. But the ultimate ruling in this case is particularly important because at that time it was the only case that was tried at the trial court and then to the Court of Appeals on the vested rights. And what the court found was that there was a vested right. The development plan carried the day for the quarry. It carried the development for all the accessory uses. Some of the buildings on the site, the way stations and whatever else, we did pull building permits for them. So we did a combo of pulling building permits where you could and then doing a site development plan where you couldn't get a building permit like the court. And I thought one of the really interesting things was it was a hotly contested case, went on for several days in front of Judge Davies, who was formerly a judge here in Williamson County. But at the end of the day, I remember Judge Davies turning to the lawyer from Metro Legal, Brooke Fox, a very good lawyer, and he said, Mr. Fox, let me ask you, what else could Mr. White's clients have done to lock in a vested right? And he said, I can't think of one thing. They did belts and suspenders. Well, that's exactly the way you need to go at it. For the lawyers in the room or the planners in the room, that's the thing you need to look at. So I'll just comment, that case was the first case to go to the Court of Appeals. There's another case that Sam will talk about, but I'll make the comment initially. The best time you can spend is working with the planning department of different jurisdictions. They need to understand an honest, straightforward approach. Here's what we're trying to do. You don't go in and say, hey, we're thinking about scales out here on this piece of property. Tell them support. Here's what we're trying to get it done. Lay them all out there. So if anybody bites you, they're not going to bite you about not disclosing everything. But again, if you lay all the cards out and meet all the boxes, then in my opinion, you've got a very strong likelihood of a vested rights approval. The act is not perfect by any stretch. And so I'd encourage anybody dealing with it to continue to look at the different matters. I'll stress again, only 2 cases at the Court of Appeals that have gone up there. Sam's going to deal with the 3rd one, but I just encourage you, we're going to have Q&A later on. There's all kinds of questions and answers. What about this? What about that? We'll give you our best shot. But with a statute that's really only been in enactment for 6 or 7 years, only 2 cases at the Court of Appeals, nobody can tell you definitively what's going to happen, especially when you're subject to a local chancellor circuit and then the Court of Appeals. That Court of Appeals has changed significantly over the years. They once were far more plugged into land use issues, not so much anymore. The days of Ben Cantrell as presiding judge at the Court of Appeals, the days of Bill Cope at the Supreme Court, who were kind of legendary in the land use era, those folks are gone. Different composition. So Sam, I'll leave it to you about the 3rd case.
Okay. First off, how many planners do we have now? How many AICP planners do we have now? How many attorneys? How many building officials? How many of you have read the vested rights law? When you get home tonight, pull it out and read it again. The old saying, words have meaning. And as the mayor of White House used to tell me, you better read it. And that's what this case is about. You better read it to understand what is in the statute. Now, some of the language in the statute is as clear and crystal as you're going to make it. Some of it runs like the Cumberland River after a good rain. Really muddy. Now, I was used to Harpeth, but too close, right? Okay, the state versus state. X-Rail Shaw Enterprises versus Thompson Station, which is right up the road. There was a preliminary plat approved in 2015. Then the town, 2018, the town updated the 2009 Energy Code. All right. Look at the dates, 2015, the vesting law's already started, right? You become vested. Now the city's adopted a new code. In 2018, what does the statute say about vesting? The development standards are supposed to stay in place for that development on the date in which it was approved, correct? So you would think, what's the deal here? We go back to whatever was adopted in 2015, and that's what we're living with. The developer applied for permits, complied with the 2015 codes for a planning group. So, Wendy, you're not out there reading that. So, arguing that it vested rights in the act. Now, here comes the fun part. The term development standards. That is what you're supposed to vest, right? The development standards at the time the plat was approved this time is either a final or preliminary development plan or a building permit. In this case, it was a development plan. We're just going to have to read this because you're going to have to get word for word on what it says. Means all locally adopted or enforced standards, regulations, or guidelines applicable to the development of property, including but not limited to planning, local stormwater requirements, layout, design, local construction standards for buildings, streets, alleys, curbs, sidewalks, zoning is provided for in subsection G, lot size, lot configuration, yard dimensions, off-site requirements, including public and private infrastructure in which any applicant may acquire vested property or vested property rights according to this section. What's left out? And what the heck does all these things mean? Planners in the room, do you recognize each and every one of those terms as something that you have? Not necessarily so. What Tom talked about, when you get in a room and you're trying to knock out a compromise at the Tennessee General Assembly, it is true. It is like making sausage. You know, because everybody around the table is going to come up with a different term. But what about this? What about that? You know, every jurisdiction may use another different term. You know, development standards. You know, when you talk about planning, local stormwater, layout, design. You know, they didn't call it a preliminary plat, final plat, construction plans. We used all these different terms that are pretty well nebulous from town to town. And oh, by the way, is this applicable to counties? Any county people in here? Well, of course, you've got the same thing. It's a mirror image, you just flopped it over. So you have to do the same thing. But there's always the but, right? What law school did they tell you? Here's the rule, here's the exception to the rule, and here's the exception to the exception. That's Tennessee Code annotated. But does not include standards required by federal or state law or building construction safety standards which are adopted pursuant to authority granted under TCA 68-120-101. How many of you read Tennessee 68-120-101 lately? Or ever read it? Well, in order to understand what the vested rights, as far as the development standards are concerned, you've got to understand what the state fire marshal's laws are. And 68-120-101 is the authority of the state fire marshal. And if you remember, and I was in this one too, I've got scars on the other side on that one. The state fire marshal, it says if you don't pass your own, we'll pass ours, in simplest terms. And that goes on for about 6 or 7 pages. So I'll simplify that for you. Okay, so you're dealing now with, okay, here's the development standards, but is that particular energy code exempted? Okay, to turn to the next one, it says, the issue at hand is whether energy code is adopted pursuant to authority granted under 68-120-101 entitled Construction Safety Standards, whereby allowing the town to acquire adherence to the new standard. In other words, you got to do it. You got to do it. State Fire Marshal is done in accordance with the Uniform Administrative Procedures Act. Anybody read that one? You have trouble going to sleep tonight? Well, that's the Tennessee Procedures Act. Not all things that administrative law judges can do or can't do. Promulgate rules establishing minimum statewide construction safety standards. Such standards shall be designed to afford a reasonable degree of safety to life and property and fire and hazards incidents to design, construction, alteration, and repair of buildings or structures. Why am I reading it to you? You can read that because every word makes a difference in this case. How do you prove what you got? You got to go back to the statute. You got to look at the statute and prove it one at a time. And it shall include, but not limited to, provisions relating to structural strength, stability, energy efficiency, means of egress, fire resistance, rating requirements, and fire protection equipment. The key word is energy efficiency there. And it may be selected wholly or in part by publication, blah, 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 the way you adopt it. So, what are we looking for here? We're looking for the fact that the city adopted these new standards after the property became vested. Who's going to win? Now, to make things a little more complicated, not that we need it any more complicated than it is. Remember, when it says development standards do not include standards required by federal or state law or building, construction, or safety standards which are adopted pursuant to authority granted under 68-120-101. So was the energy code adopted under that standard? Or cities and counties can not adopt those codes, but adopt them on their own, locally adopted codes. Now, according to the law, if it's locally adopted, they're vested, right? They're not the state fire marshal's codes. They're local jurisdiction said, nope, we don't fool with the state's codes. We'll adopt our own. Those are vested. Only those codes that are state or federal or through the fire marshal's office like this, they may be changed, and that was the hope. The courts basically said, look, they were adopted under the state fire marshal's code. State fire marshal's code are state and federal rules and regulations that the statute says can be changed. Therefore, Mr. Developer, you're going to have to adhere to them. Pretty clear, huh? What is adopted, what isn't adopted? Where did it come from? And that's the key here. Where did the code come from? So you've got to know what I often tell boards of zoning appeals, bless your hearts, that you got to know more than the 3 powers that's introduced in the statute. You've got to know other things, like the Tennessee Religious Freedom Act, the definition of agriculture. Now, they're not necessarily right there in front of you in that section of the Tennessee Code annotated that talks about boards of zoning appeals. You must know other factors that come into play to the decision of the building inspector. Here you must know other factors that where do these codes come from? The city said, no, we should be able to charge this, make sure they adhere to the codes. The developer says, naturally, no, that's going to cost me too much money. And plus, we're vested. In this case, they weren't vested in those codes. You want to go on, Tom?
Let's start with some questions. Or, Tom, did you want to speak for about 5 minutes? Did you have something you want to say, add to that?
Just a few things, Patrick, I would say, and that is that there's some very capable lawyers in the room, obviously very capable planners too, but it's important to remember that a lot of these cases we're talking about end up in front of your Board of Zoning Appeals, where they make a decision. A zoning administrator makes a call, ends up going to the BZA, and the record at the BZA is what controls. And I think it's very important that you realize that at the Board of Zoning Appeals, in the cases that come out of it, they're limited to that record at the board. Even very capable lawyers sometimes miss that. And you can have a very contentious hearing, and the lawyer on the other side may not realize when it goes to the court, and it can go to Chancery or Circuit, most of them go to Chancery, you're limited to that record below. And what I think is important to understand in matters like that is that, I'll give you the classic example. Oftentimes you know you're going to lose in front of the Board of Zoning Appeals. I was the lead lawyer in the Father Ryan case against Oak Hill. It was a very simple matter. The old Father Ryan down on Ellison Place was in incredibly bad shape. They needed a new campus. And I got called by the diocese and I said, whatever you do, don't buy the property. It was a 40-acre tract off Hillsborough Road. I said, take an option on the property because it's going to be contentious. Well, about 3 months later, I got a call and they said, well, we bought the property. What do we need to do? Well, that began a saga where you knew you were going to lose at the Board of Zoning Appeals. And it was pretty clear, I want to be fair to the people that were opposed to Father Ryan. There were like 8 houses on Railroad Drive. That went from like 20 cars a day to sometimes 1,500 cars a day. So you had to understand the legitimacy of that. But we tried the case in front of the Board of Zoning Appeals. My job was to make sure that I had every witness lined up to say, we complied, we complied, we complied. And the cases are very clear about unfounded concerns of neighbors, like, hey, there could be a lot of traffic, could be this, could be that. They're not counted by the court. You have to have experts in to really talk about the different things. And the testimony was going extremely well. And the last witness that testified was a traffic engineer who lived in the neighborhood. I thought, oh my God, here we go. This guy's going to come in here and say, look at this. He went on to say, this is really a bad place for this and this and this. I said, thank you. He sat down. It was such a hostile environment. I've tried cases for quarries, landfills. There was never anything quite as hostile as the Oak Hill reception. When we finished the case, there was a 3-person BZA panel. They said, we're going to take a break and we're going to give a decision. So in the public forum there at Oak Hill, they turned around. The chairman pulled out of his pocket the decision. And he turned back around and said, here's our decision. I mean, obviously they had made it in advance. That was it. So we ended up winning the case at the trial course in front of Chancellor Kilcrease, came through the appellate process and won. But what I think was a real surprise to the lawyers who were on the other side was they were limited to that record. You couldn't go back and take depositions. You can't supplement the record. You're stuck with the record. And then just a little bit of humor about it. When the case was over, it went to the Tennessee Supreme Court. There was somebody working for the diocese named Randy Campbell. People here in the room may know him. He was on the planning commission in Brentwood for years. very capable, bright guy. He called me and I said, go down to Oak Hill and get the building permit for the school. And so he called me a couple hours later. He said, you won't believe this. He said, I went in to see Bud Morris. He was the city manager, legendary city manager for Oak Hill. He said, I went in to see Bud Morris, and he said, we're not giving you the building permit. And he said, you Catholics are like the blacks in the 60s. You always want to be somewhere you're not wanted. And I said, Randy, you must be kidding me. He said, no. I said, will you give me an affidavit? He said, of course. Well, I filed a contempt of court against Oak Hill. They should have realized we were in front of African-American Irvin Kilcrease as the chancellor. It was not well received, and the permit was issued very quickly thereafter. But I will say this, to Bud Morris's credit, he was not in the politically correct role. He didn't come back and say, that's not really what I said. He just said, yeah, that's what I said. So I give the guy a lot of credit for, in today's world, it would have been a different, that's really not what I said. Anyway, little humor about the Father Ryan case.
A little bit on planning commission and board of zoning appeals, and when you get this, a lot of times on a vested right, decisions going to be made by the building official, and it's going to go to the board of zoning appeals, because that's our first power of the board of zoning appeals, is to take cases in which I disagree with the ruling of the building official, right? That's first power, number one, before they do anything else. The record, as Tom was talking about, the record. Tom's partner, how do I put this? Lost a case not too long ago. Not because he was a bad lawyer. It's because his client was a bad client, if you put it that way. Sometimes you get them, right? But the case turned on one issue and one issue only. Who had the material evidence? That's what happens here in this building code issue here, investor rights. Where is the expert? Where's the material evidence? Who's going to testify? Somebody could testify, well, this isn't, I could go up there and say this isn't or this is, but I'm not an expert on codes. I'm not an expert on the adoption of this. I'm not with the State Fire Marshal's office. You get the best person you can find to testify for you on a material evidence case. Not a neighbor, because as Tom said, non-experts, the courts are going to say that's not material evidence. So when you're looking at issues like this vested right, get the people in front of you that know what the law is and know what that statute happens to say and know what the condition is. And, again, all the different, we've got development standards, all the different things in the development standards. If I was in Murfreesboro, I might get the planner for Lebanon to come over and testify. Is this a development standard or is it a development standard? If I was in Franklin, I might go to Murfreesboro. Somebody that's an AIC planner or experienced planner to help define what that is by looking at the code itself and how you write those definitions in your own regulations, in your own ordinances. Okay. Next.
Gentlemen, I appreciate the overview of the Vested Property Rights Act, and I think this is a good jumping off point to get into the nuts and bolts of it. And for the audience, I've compiled a list of questions and hypotheticals that I'll start putting these gentlemen, and then we'll talk about best practices, and we'll take questions. So if you have questions, please write them down, and when we get to it, I'll ask for questions, and you can stand up and voice your question, and we'll see if we can get these guys to give us a definitive answer. So the first question, Tom, and Sam touched on this, so this is why this is a question from you, and it's frequently an issue with developers. But we all know that climate is changing and floodplain regulation is becoming much more of an issue. It seems like the old 100-year floodplains are now 10-year floodplains. So one of the questions from one of our engineers is, what are they to do when the federal floodplain regulations change when a project is already vested? And I can tell you from a city perspective, we get a lot of pushback from this from developers. And since you often represent developers, can you share with us how you guide your compliance on this issue?
Sure. Since I almost always represent developers, and I don't like to give this answer, I should say I'm taking under advisement. But the answer is the developer loses. It's very clear on floodplain issues that are specifically exempted, and they should be. I mean, despite the fact that clients that I represent don't like that, floodplain issues really are, they preempt the vested rights. That's all there is to it. And people can discuss it, they can argue about it, but at the end of the day, any change in floodplain, no matter how much of the nuance, controls.
Perfect. Sam, do you have anything to add to that?
No, Tom's exactly right. Developer loses, city wins.
Perfect. Sam, I have a question about major modifications from you. Occasionally, and it seems like more often now, with the economy changing, but we will get a request for a major modification. What does that do to the vesting clock? If it restarts it, can the city reject a major modification just to avoid restarting the clock?
Well, first off, no, you can't reject it just because you don't want to restart the clock. A major modification can be done by the developer, but it must be submitted to the city or the county, the planning commission, for approval, because you're vested under the old development, and in order to be vested under the new proposal, you got to go back and have it approved. Now, if the city can or the county can deny it, simply on the fact of it's changing the density, it's changing the uses that are allowed. There are factors in the statute itself that says here's what you must consider if the developer wants to come back in and change a vested development, and you can do that. You can also not do it if it meets one of the criteria for not allowing that to happen. But just saying nope, I don't want to, I want to mess up with the clock. That's not easy.
And so what does that do to the vested rights if a major modification is granted?
Then you pick up at that point in time, and you still have the total of up to 15 years of a multi-phase development. So I think, in my opinion, it doesn't change the development time frame. It just changes what's allowed and what you're allowed to do in that time frame.
But it doesn't change the clock.
It does not change, in my opinion, it does not. Now, there may be others that say, yeah, it does, but in my opinion, it does not change the clock.
Tom, what say you on that issue?
I probably disagree with Sam on a little bit. One more time, there's no case authority on this, but if you look at the Vested Rights Act, and anybody read through the legislative history of it, what's replete in all the comments by the state legislatures was a sense of equity, that developers could spend a lot of time and a lot of money, and then have the rug pulled out from underneath them, like the Howe case that we talked about, our 1940 Nashville case. And so I always urge clients, as I think I said at the front end, if you've got a good city attorney that knows land use, Patrick Carter's a classic example, you got Pam that knows land use law, the most important thing is to be just straight up, here's the time and money that we've spent, here's a major amendment. This is what I would agree with Sam and then disagree. I agree, the city can't just say we don't want to look at it. That's not a reason. They've got to look at it, have a right to be on the agenda, have a right to be heard, period. I do think this. I think if the city grants a major amendment, my opinion is it starts the clock again. Because they're basically saying, look at all this time, look at all this money. Major means major. And so if you're going to spend that time and money, I think the clock starts again. If nothing else, there should be a discussion with the city representatives about, hey, this is something, it's major, it's significant, here's what we're thinking. And then if nothing else, have some agreement about how it phases in from year 3 to 15. You can do that. It can be done legislatively. And I would always encourage any client coming in with a major amendment to spend the time with the Pams, the Patrick Carters, lay it all out there with your engineer, being absolutely clear they understand the amount of money and time. That's what plays into the vested rights thought tank, the DNA that got the bill enacted in the first place. So in my opinion, if they do enact it, I think it starts again.
And I think that basically we're talking about vesting standards. And the modification has to do with the actual development itself, not the standards within the modification. modification, maybe, maybe not, but, you know, I think what you're talking about here is we're allowing the standards to stay in place. The purpose of whatever's happening within the development may change upon the approval of the planning commission at that point in time. But Tom's exactly right. Nobody's tried this one yet. So, you know.
I'm winning so far.
Yeah, so far, you know, but until, you know, the Court of Appeals makes a ruling, until somebody does this, you know, we don't know for sure. It's speculation, you know. It's speculation on my part, you know. I can tell you what I would advise the planning commission to do, but, you know, again, what the court's gonna say, if I knew that, then I wouldn't be sitting here, because I'd be making a lot of money somewhere else, telling you what the court's gonna be doing. And so, we tend to disagree to a degree.
Well, Sam and Tom, I appreciate that because Ms. Caskey and I have an ongoing disagreement about the effect that kind of breaks along the lines of what you've talked about. So I'm glad that we're not the only ones that are having that conversation. I think this next question, and this is for either of you, and it kind of builds on ordinances that are vested, and I believe this comes from one of our codes enforcement staff. But the question is if the ordinances that are vested, is it just the ordinances that are vested or the standards and specifications that are also vested? If yes, does this mean that if old technology becomes outdated and the specifications are changed, are we stuck with the outdated technology for 15 years?
My comment is all of it is totally covered by the Vested Rights Act, ordinances, everything underneath it. The exceptions are things like floodplain, like the case that Sam talked about with the energy code. But as far as the city ordinances and subparts, that clearly is, in my opinion, undisputably vested.
I agree.
So in Spring Hill, and this is probably like most cities, we kind of have a complex weave of things that are included in our Uniform Development Code. We have a code of ordinances, so you're saying that would be vested, correct? We have subdivision regulations, and you're saying they would be vested as to when the project was approved, the first 3-year vesting, correct? And if it's extended, it extends. Design review guidelines. What about design review guidelines?
I think they're covered.
Okay. And the zoning ordinance, of course, is covered.
Absolutely.
And as far as things that aren't covered, you're talking about federal and state regulation like floodplain. Other than floodplain, what else falls into that category in your opinion?
Well, the energy code, everything Sam covered in the Thompson Station case. But again, I think the real litmus test, Patrick, is it a health safety issue? And that's really what it all comes under, whether it's floodplain, floodway, energy code.
Fire code.
That's the type of thing where I think you just need to advise your client. You need to salute the flag on that. It could be a significant increase in cost, but you're going to lose that one. But that's the one where I would urge the builder developer and their engineers, it's often the engineers that's at the table negotiating, is to sit down with the city folks and say, look, this has been changed. We've got 6 phases. We're in phase 2. Can we start this at phase 4? So I can plan ahead, talk to my lender, make sure they understand the increased cost, be sensible about it, as opposed to a draconian line drawn by the city or county saying, we're starting this on your next building permit. And that's what's lethal to the builder developer. So that, in my opinion, that type of relationship with the people in government, where they'll understand the whole purpose of the Vested Rights Act was equitable. And so you don't want to catch somebody short. How about phase it in? That to me is the way these things ought to be handled. And oftentimes are. One of the cases that brought about the Vested Rights Act, I was talking to somebody earlier that works with Bill Coates and Steve Cates, and that is, they had a project in Nolensville. And they got into, I think it was phase 7 of a development. And Nolensville decided they were going to change the street standards. Now this is pre the Vested Rights Act. And so at the end of the day, they got ready to do phase 7, and the city said, excuse me, roads got to be wider, they got to this. There was a big economic hit. Well, the lawyer representing CK, Jim Murphy, a good friend of ours, excellent land use lawyer, lost the case at the trial court and at the Court of Appeals because they said it's a health safety thing and you didn't have all your permits in line for phase 7. Well, I really disagreed with that decision, but it was the law until the Vested Rights Act came out. But I was teasing this person earlier when the Vested Rights Act came up at the state legislature. At this point, Steve Cates was one of the partners with Cates Codas, was a director of one of the departments for the governor. So when we were looking for support for our bill coming through, there was no question. I had to ask Cates one time, and he was at every committee hearing telling everybody about how unjust it was to change the guidelines. And that was in part the whole equitable regimen behind the Vested Rights Act. So I think the equitable thing is phasing things in. That's a relationship. And if it can be phased in safely, shame on city and county if they don't try to work with the government. It's going to be.
In my view is, you got what you asked for. You know, I was there, and believe me, vested rights needed to be changed in Tennessee. You know, you would think, I'm a city and county person, why would I say vested rights? Well, one of my jobs is to go around to cities and counties saying, what are you doing? Why are you doing that? You know you can't do that. What are you doing? Well, because we think we can. No, you can't. You know, my job for many years was to go around and say, stop it, you're not supposed to be doing that. You don't have the authority. Me and Dillon's rule were very friends. You know, I'd go around quoting Dillon's rule until, you know, it was almost like I dreamed at night. If you ain't got the authority, you can't do it, people. Kind of deal. Well, what happened in the two cases that Tom talked about? One was Nolensville, and I believe the other one was Juliet, I believe. Memory serves me correct. The city did things they weren't supposed to do. So the developers were legitimately concerned because the rules of the game kept changing. You know, and I don't think anybody can say, you know, the rules need to be for everybody. So if you start under this set of rules, it's kind of like with some friends of mine that took more than 7 years to get out of college. You know, which book did you come in under? You know, what was the requirements when you started? You know, that's what you kept with for all those years until you were in your 9th and 10th year. And I knew some that way. Not they didn't go to Vanderbilt though. They went to public school. Oh. But you know, the developers here had a right to anticipate developing under the standards, and the city was changing the rules, and that was wrong. And I agreed with the developers on that point. You know, city, county, you need to stick by what you started with there. Now, and just as the fact that that's what you know you're doing, and all of a sudden we change the rules. Well, you're going to have to change the development, and I thought that was wrong. Where I disagreed with the concept of the bill, it went a little bit farther than just subdivision regulations. I was dealing with subdivision regulations more than anything else. But you know, once they got this bill passed, to the extent that it was passed in, you got to follow the letter of the law, in my view. So if there's interpretations, and Lord knows this is not a perfect piece of, I don't know that I've written a number of pieces of legislation. Can I say I wrote a perfect bill at any time? No. You know, usually before I wrote something, I read it 5 or 6 times, passed it to somebody else, let them read it 5 or 6 times, and then changed it totally. You know, there's nothing perfect about these. But the beauty part of legislation, the beauty part of your own rules, you know, if something else comes up, is that you can change it. You can change nothing. Nobody said you can't change your zoning ordinance or your subdivision regulations. You just can't change that particular development's rules. So if you need to modify your own to let technology go up, fine. But you may have to bite that bitter pill and say, well, you have to keep going the way you are, and the next guy has the new rules after we've adopted it. So I can say, you know, especially with boards of zoning appeals, keep picking on you guys, but you know, Uses permitted until conditional uses. If the conditions aren't there, you ain't got much to go by, do you? So, sometimes you have to approve something even though you don't want to because it met the conditions. Now you go back and you go to the planning commission and have the conditions beefed up, goes to city council and they pass it. That's the same thing here. Sometimes you'll see that what you're doing is not adequate. Change it. But the people that are already in the trenches, you gotta let them go. Even though you don't like it, you gotta let them go. And that's fair to the developers. Anybody tells the group, anybody developers in here, if you go back and tell the Developers Association that I said we gotta be fair to developers, I'll do not.
We would love to entertain a question from the audience. Do we have any questions? If so, please, Lance, will you please stand up and address your question? And first, tell everybody who you are, so we know your background.
I'm Lawrence Holbrook. I'm the city engineer. My question pertains to approved plans. So there are plans that have been designed by an engineer. Those plans might have been lacking certain information or were designed not to meet the standards that were approved or that were in act whenever it was vested. Does that set of plans, whenever it was found to be short during construction, have to be revised to meet the standards for which it was approved under?
And Patrick, I don't know that I heard every bit of that. You might need to come up to the mic. I heard
most of it, but I'm not sure I can word the question well enough. There was a question over here as well, wasn't there? If you want to come up and stand behind Lance, we'll take you. We'll take you in order. How's that?
Just yell real loud. We're used to people yelling at us.
Okay, I'm Lawrence Holbrook, city engineer. The question I have was plans that are designed potentially did not meet the standards that was found during construction. The plans were passed by the city, approved by the city. Are they vested to install those infrastructure, not to the standards that it was approved under?
In my opinion, it's a little difficult to answer, but I would say, the enforcement arm's the city. So if the city approved it, I think you're going to be okay. Now, let me just say this. There's a classic case in Nashville. Sonny West was our zoning administrator for decades. There's a classic case where he gave the approval as a zoning administrator. Somebody started a lawsuit development. And the court said if it wasn't allowed appropriately, then it's a nullity. My comment to you is that if that's done and the city salutes it and you continue with the project, I think you're going to be fine invested. But you have to remember, if it's just at the very front end, and then there's a piece of litigation over what you're talking about, you may well have the Sonny West result, which is that it's rescinded. In other words, if a court decides the city, through the zoning administrator or the city approval process, was clearly in error, they approved something that was not allowed, you might be back to square one. If, however, you get into that project and are significantly long, I think you're clearly going to be arrested by any equitable standard.
So it's on equitable standards. Okay.
I think I heard you say the development is vested.
The developer?
The development is vested. To
Yes.
The standard that it was approved.
Yes.
You're talking from the developer's perspective, and he's representing the city, so.
That's too bad. We'll still take your question.
All right, Sam, anything to add to that?
If I understand, let me make sure I understand it. You had a set of plans that were worked on by the engineer for the development. They were submitted to the city. They were approved by the city. And then during the construction phase, you found that they were inadequate. They did not meet the requirements of the city at the time. Is that what you're saying?
Yes.
Okay. Then, there's that tooth theory where the city stamped it and said it's okay. But there was also the same thing that Tom talked about, is that, if it was illegally or improperly done, then it was not done at all. I go back to my friends in Rutherford County, Allen versus, Edwards versus Allen, not me, in which a rezoning was nullified because there was a problem with the notice, and it should have gone back to the planning commission. Well, the point of the whole case was this, if it was a nullity at the time of its passage, it's a nullity now. So if it was incorrect at the time in which it was submitted to you and you didn't catch it, it's still incorrect. And I think you would have an opportunity to ask them to correct it.
The only thing I would add to that is that we need to talk about what was the gravity of what was missed. In other words, my opinion is you're going to have in front of some chancellor or circuit judge. If it's a health safety issue that was just missed, then I totally agree. You're back to square one. If this is a nuance where it's supposed to be 2x6s versus 2x4s, I don't think any judge is going to basically rescind it. It depends, in my opinion, on the magnitude of what was not caught. Again, health, safety, welfare, the developer is going to lose. That's out. But at the end of the day, if it's something relatively minor, not health, safety, I think the courts would let it go.
Tom has more respect for chancellors' ability to correct.
Thank you, Lance.
Sometimes I'm a little bit.
I think we have another question from the city attorney for Murfreesboro. Yeah, if I have that
Come on,
right.
David. A friend for many years.
Good afternoon, everybody. I'm David Ives, Deputy City Attorney of Murfreesboro. With the site plan under standard zoning, site plan is approved. That site plan, no doubt, was vested. Then a neighbor sued over questionable of who owned the strip of land next to the road that the development was going to cross. And also there was the plan got rejected by our codes department because they put an air conditioner in the front yard right in front of a window, and it was determined later that that window was a bedroom, and the air conditioning HVAC unit in front of it hampered ingress and egress, so the codes department rejected it. Time passed as they went through the litigation. They come back with a different plan, and for a variety of reasons, their amended plan was rejected. The law says that if the amended plan gets rejected, you can go back to your original plan. Problem that they can't build the original plan because of code requirements and the litigation that was settled pending approval of the plan. So where do we go with that one?
Hypothetically
Thank you. Thank you, David. You were my friend. Okay. Now, this is my view, okay, on this. What was vested was the site plan. That's what was approved. What has changed about the site plan? What you're changing necessarily is, the installation of the air conditioning unit and maybe two internal things.
Road access.
Yeah, on access. So, was that actually part of the approval of the site plan? Was that detail approved by the site plan? What's vested is putting that project on this piece of property. Okay? Now, if that's what the city approved, the issue now is the building permit. And I assume they pull a building permit. So the rules and regulations at the time the building permit was granted is what you have to live by. Now, every building permit I've ever dealt with didn't get into necessarily all the detail on a single structure on where the air conditioning stuff is. Maybe it is, maybe it isn't. Depends on your city. So, the building permit is also vested.
Haven't gotten
Hadn't got to the building permit?
there. No.
Okay. No building permit. So what you've got is an approval of the building being right here. It's on the site plan, correct? Right? That's what's vested, what's
well, of course, the access to the site, which can't be done the way it was planned.
Then that needs to come back to the planning commission.
It did, and it wasn't approved. The modification was not approved.
Modification was not approved. Under what
The
basis?
amended site plan, that had a variety of amendments, was not approved.
But, you know, you can only deny an amendment because it alters the proposed use. That didn't alter the proposed use.
No,
Increases the overall area of development. It didn't really do that.
no,
Alters the size of any non-residential structures included in the development plan. It didn't do that.
no, but not size, but layout.
Okay. Increase the density of the development so as to affect the traffic, noise, or other environmental impacts. It really didn't increase the density.
No,
Increase any local government expenditures necessary to implement and sustain the proposed use.
not materially, if at all, not material.
Now, according to the statute, A, B, C, D, E are the only reasons to deny. If it doesn't fall in that category, then the denial probably shouldn't be granted, shouldn't be given. The approval should have been according to this. You know, that's what the statute says. Here's the only reasons you can deny that amendment. And if he doesn't fall within those categories, then why did you deny it? Is it a health safety reason? You know, and did you make a mistake when you first received this? So I would say, sorry guys, probably you shouldn't have denied it.
I would say the details of the denial I would not want to discuss at this time.
Tom, do you have
As always, you're a wise man.
David, I agree with Sam's comments, and as you well know, I'm always here for the developer. It makes absolutely no sense not to allow them to move forward. It's clearly not one of those things that are excluded. And it's one more time my comment about common sense. I would be down there as the attorney for the developer saying, come on, it's not in these items, let's go. You know, what's the purpose for this? And how many hundreds of thousands of dollars has my client spent getting to this point to start talking about this issue now? So I don't know the Paul Harvey rest of the story that you're talking about, but I think the developer ought to win that.
Right. But part of it is the question of since they can't go back to the original, if they were able to go back to the original plan, I don't think they'd have much of any problem, they could just do that. But because of the lawsuit, code problems, code issues, they can't do that, so they're somewhat in a rock and a hard place. I recognize that.
A developer can always go, time out, I give up my vesting, and I will redo my plan. And you can do that.
We wouldn't want to do that.
I know, I'm just saying, trying to be reasonable. You know, you can say to a developer, look, you know, if we're having such insurmountable problems, you know, you can just withdraw this proposal and give up your vesting and bring a new proposal in. Once you bring a new proposal in, basically on the same piece of property, you are starting, and that gets approved, you're starting investing on that development plan, and you're giving up the other one. You can give up a plan.
Tom, how many times have you advised clients to give up a plan?
I don't think I've ever heard that advice. I certainly wouldn't want to. And, you know, Sam sometimes veers over here on the dark side with these suggestions when they're explaining to a client who's borrowed a bunch of money at the bank. Why don't you just restart this thing and let the bank foreclose on your property? Generally not well received. So I've hesitated to give that advice.
That's why I work for the city and county.
Thanks, guys.
Mr. Dempsey, could you introduce yourself and ask your question?
Thank you, Patrick. Jerome Dempsey with Thomas and Hutton. Consulting engineer. We run into a lot of times that water and sewer specifications have been submitted to TDEC for renewal and approval by the cities. Say you have a development that comes in And are they vested under those old specifications, even though the construction has not started? Say that the city resubmits to TDAG and there's an improved product, say you're now specifying ductile iron pipe with 401 liner rather than a PVC pipe. At what point does that development become vested with the specifications of water and sewer that were in place when it was approved, even though construction has not started?
My view, let me ask you this. Are the specifications the state's or the city's?
Both. Well, they're the city specifications, but they're approved by the state.
Okay, but does the state have specifications to back those up? That the city-
In certain instances,
And if
design
it's-
requirements.
I think if it says anything to do with the state specifications, you know, they can be changed. Anything to do with the city specifications that does not involve the state Department of Environment and Conservation, I think basically those are vested. But if the state changes it and say we want to change, then that's going to be we're going to have to make the change because it's a state requirement.
Unfortunately, I totally agree with that. If it's a city requirement, obviously it's locked in. If it gets to state, no question, the state trumps.
So even though there's an old product and those specifications that was intact when the development came through. And my second question is, how long are the vested rights? Say something comes in, gets approved, and you've got a 20-phase development that's
3, 2,
projected for
5, and 15 years.
up to 15.
If it's a multi-phase project. Or until the project's completed, but no more than 15.
Pam Caskett, City Administrator, again, thanks guys for doing this. I have two questions. The first one is, we have a collection of ordinances that are not related to development, yet they may, because development may be subject to them. Specifically, I'm thinking about construction hours and noise ordinances for construction, or for construction routes, how a construction route is going to be taken. If the board decides to change those, can the developer claim that they are vested under the old rules for the lifetime of that lifetime of that vested right? Because they are city ordinance, they're not state, but they're really not development ordinances, they're more general broad ordinances.
My comment, Pam, is that I strongly feel the developer should be protected and would be able to claim that because it's not one of the items that Sam mentioned here. But that's one more where I would hope, as the lawyer for the developer, I would be down talking to you and Patrick saying, hey, look guys, we've got a development over 3 years, here's what we've done. We'll try to work this out with you. Can we think about putting this in phase 4? But at the end of the day, I think unless you want to call that house safety welfare, and I kind of think that's a stretch to do that, I think you're probably locked in being protected. But again, my client would be sitting there with the advice from me, get down there and work it out with the city.
Yeah, I would say, if you look under this, what is the development standards? It's loosey-goosey. Depends on where it's written, how it's written. You know, local construction standards for building streets, alleys, curbs, sidewalks. You know, as part of the construction standards, do you have the hours of operation, noise ordinance to be part of that? Depends on where it's located. So I think I agree, I think it's going to be part of the construction standards, the development standards.
I was afraid you were going to tell me that.
Sometimes I don't get good news.
And Pam, all I can say is hope that's one of my clients.
Yeah, I think at least a couple of them are. The other question is, so I think I've learned two things here, and maybe I want to articulate this for all the city officials in here. It seems to me like anything that is not known at the time of the approval, like what construction route you're going to take or something like that, has to be conditioned in the site plan to be identified as something that will be determined later. And that would give the city and the developer an opportunity to talk about it.
I think the site plan is what controls, you know, it's called development standard, site plan, whatever. That's the time, and Spring Hill does a particularly good job of vetting those types of things. It avoids the confusion down the road where those things are discussed. They should be in the site plan, and that's, as an example, why in that Hoover case, we were allowed to have all the accessory uses, the asphalt plants, cement plants, because we were very clear that it was accessory uses as well. They were identified. So to the extent things like that can be identified, they clearly need to be. If they weren't thought about, probably the developer is likely to prevail because it can come under the umbrella of the development standard. But it's the type of thing where I don't want my client getting picked up, you know, in some municipal court for some violation. So you pick up the phone and you try to make sure people understand that wasn't discussed. Now we've got a new hospital next door where the hours could be an issue. What can we do? That's the type of thing. Hopefully common sense will prevail.
And I think the other thing I've learned is that any time we can write a standard that's related to the state standards, we are protected.
Unfortunately, you are. Yeah, if you can hang your hat on a state or federal requirement, it's going to be enforceable. So I'm sorry that you've learned that rule.
Don't do, you know, I'm also, sometimes I have one hat, and I'm also administrative hearing officer for a city. And which means, you know, here's plumbing code, building code, et cetera, and zoning. It was also included that list of what administrative hearing officer can hear a case under. And in one situation, I got something similar to that, where the planner sent a complaint over to a developer, and she didn't cite one, oops, I said this person did not cite one thing from the zoning ordinance. Instead, she was citing things from the federal law, EPA. I politely dismissed the case, being that I don't think the state of Tennessee, when they wrote the administrative hearing officer law, gave me jurisdiction over federal law. So, you know, be careful on where you pick up your words. Another thing is on your standards, when's the last time you reviewed them? You know, you're supposed to be, those of you that are members of anybody on the planning commission? Oh, come on, somebody's got to admit it. Okay, there you go. You're on the planning commission. Your job's not just to sit there every month going, well, here's your site plan, here's a subdivision plan. You're supposed to be planning stuff and reviewing it and changing it when conditions. Planners over there, you know, God help them. The ones that I know can, you know, they're up to here with stuff that comes into them every day. They don't necessarily always have time to go in and say, oh, we're going to rewrite the general plan for Murfreesboro, or we're going to do this for Franklin or Brentwood. You know, we're not going to do all this, you know, because we don't have the time to do it. But that's something the planning commission has to take hold of and go, look, you know, we need to review these. I tell members of the planning commission every time I talk to them, here's the things you need to bring into the meeting with you and understand, and understand, and understand. It's the plan, your general comprehensive plan, your subdivision regulations, and your zoning ordinance. I'm amazed sometimes that members of the planning commission have no idea what's in them, you know, and what they can and can't do. So don't be afraid to change things, but you do need to look at them periodically to make sure they're up to date. Now, I'm going to skip a little bit. One of the things vesting means is how big is your filing cabinet? Because in 2022, whatever developments you proposed and approved, you need to have a file that says, this is what the zoning ordinance said, this is what the subdivision regulations or any other standards you might have. This is for everything that was approved in that calendar year. because that's what's vested. You've got to keep up with what you've got. You know, we were talking about the record earlier. That's part of the record. In case somebody comes in and challenges you, you need to be able to take to the chancellor, this was the rules in 2022. So, you know, make sure that there's a system that you have. I guess this goes to best practices.
Oh, that was perfect, 'cause that's what I was going to ask next.
There's a system you must have to make sure you keep up with all those records and all those standards, you know, and figure out what's best for you. Some jurisdictions have 20 plats a year, some people have 20 plats a month. You know, some people have, you know, maybe look at the site plan once every now and then, and some people got them all the time. So keep the records, because you have to have the records. In order to invest.
Tom, do you have any input on that, how to keep up with what can become a complex amount of information over time?
Yes, Patrick, I say very candidly, there's a job for a lawyer to do, there's a job for a planner to do. I give a tremendous amount of credit to a good engineer. I mean that as sincerely as I can, because the engineer is the one that basically decides, do we or do we not fit into the box here? They're generally bright, well-trained. They'll look at the Spring Hill, City of Nashville, Murfreesboro. They'll look at the ordinances, zoning regulations. And so I'll be candid, I have a very significant amount of reliance on engineers and what they do. And as far as best practices, I cannot represent to a client that I'm going to look at every single thing on every single requirement. The first thing I'll say to a client is, who's your engineer? And generally, I work with every engineer and architectural firm in Nashville, but there's some that I'll say, I really think that's a good choice, because they'll do the very thing we're talking about. They're the institutional knowledge is what I'll call it. And we'll try a lawsuit. In my file, you know, on, say, the Hoover case, you know, it's a thick file, a bunch of red books. It's nothing compared to what the engineers had. I mean, they were there on every single thing. And so my comment is, I think best practices to basically continue as a lawyer to do summaries of cases all the time. I do that generally at the front of a case, middle, when I wrap up a case, I always do a dictation of notes to the file, where I'll remember what the different things were, the different comments that were made, and some of the specific things. Like at that time in Spring Hill, the ordinance said this. This was a keynote thing. And so my comment is lawyers need to do a better job with what they're doing, but you're making a big mistake as a lawyer if you're not heavily relying on the engineering project. That's my answer for best practices. Onus is on the lawyer to know that to your client, but you can't do it in the detail that a good engineer can.
Perfect. Gentlemen, I think it's the witching hour. The time has flown by, and I really appreciate both of you coming to Spring Hill today, sharing your knowledge with us. I think a round of applause is probably in order. Thank you guys. And are you going to stay around a few minutes? If anyone has any questions they were nervous to ask in front of the whole audience, I'm sure these gentlemen would be happy to answer them.
Patrick, I do have to answer one thing. Patrick and I were talking earlier about how oftentimes as a lawyer you get legal advice, you think to somebody, you're really not interested in getting legal advice, they're interested in what's the bottom line. And I commented to Patrick, one thing I'll never forget was many years ago I represented Porter Wagner. We sued Dolly Parton. And Porter Wagner was the big star at the time, and had been on his country music show was 22 years, and he's the one that gave Dolly Parton a break when she sang on the show. But at the end of the day, they had a contract that said that if Dolly ever left the show, she would X part of her income to Porter for like 5 years. Well, she left, and the first thing was her family did was really a millionaire. But then 95 came along, Jane Fonda, etc. And all of a sudden the money popped up. And so she got bad advice from a law firm in California, and we sued her. But at the end of the day, when we got the whole matter resolved, at the time, it was confidential at the time, but it was millions of dollars that she owed to Porter. She didn't have the money. And so her lawyers and I worked out an agreement where there would be insurance on Dolly's life where Porter was the beneficiary. But her lawyers were very clear and said, whatever you do, don't mention that to Dolly. I said, don't worry about me. So late that night or early morning, we're inking the final settlement agreement. And Dolly Parton flipped to the page about insurance. I thought, oh my God, here we are settling this thing. And she said, wait a minute, what is this about insurance? So I gave her a great lawyer's name. I said, well, you know, Dolly, you don't have the money right now to pay Porter. That's how it's going to be funded. She said, Tom, you've been around us for a couple of years. There have been guns and knives and lots of fights. And so I gave her another great lawyer's name. I said, listen, Dolly, you know, under Tennessee law, if you procure the death of the insured, you can't get the money. And she looked at me and she said, damn it, Tom, I'm not worried about you. I'm worried about Porter. He doesn't know what the law is and doesn't give a damn. So a correct legal answer is not always the right answer in planning or anything else.
And also the moral of the story, don't go to California for your law.
Thank you, guys.
Thanks for letting us come.